Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day. And for those of you in the United States, happy Memorial Day weekend. And I hope that the situation wherever you live is such that you will be able to have some kind of Memorial Day activities, at least to remember the troops who gave their lives for us for the freedom to engage in barbecues and meet with family and do all the things that we love. So, first, thanks to the troops who made this stream possible. We wouldn't have much of a First Amendment without the troops to defend us, so thank you. So, we are here to talk about the new Title IX guidelines that have been published in the Federal Register as a final rule this week. Very exciting. First of all, we'll begin with the text of Title IX. It's a very short law. Here's the entirety of Title IX. Quote, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. That's it. That's the entirety of Title IX. It's a very short law as part of the Education Act. And as the text says, what it prohibits is discrimination on the basis of sex in an education environment that receive federal funds. Now, this includes federal loans and federal grants. So even private schools, private universities are covered by this law because they receive public grants and public monies and public loans. So they qualify because of those things. So this applies to private and public schools alike, and it prohibits discrimination on the basis of sex. Now, what is that meant to encompass, or what does it encompass, I guess is a better way to ask the question. Well, what it was meant to accomplish, who knows? A lot of people think it was only meant to equalize sports. Before Title IX was passed, women's sports didn't get a lot of love, and after Title IX passed, women's sports and men's sports have to receive equal funding. They obviously can be different sports, but they have to be funded equally in gross. And as a result of that, women's participation in sports went up. I forget the exact multiplier, but it was several times. It was something like 7 times or 12 times. It was a fairly significant multiplier that women's sports increased as a result of Title IX. But it has also been used for purposes outside of that. For example, to go after sex discrimination that occurs on campus. So the most obvious example that this could occur in is if a professor is sexually harassing a student. That would be sexually based, and they would be discriminating on the basis of sex, presumably, and therefore it would be a sex-based discrimination. So the idea of a professor engaging in sex-based discrimination against a student has been read into this. And likewise, a student engaging in sex-based discrimination against another student if it is occurring in the educational context. And that is where the schools enter this mix as it relates to students who are accused of sexual misconduct against another student because they don't want to have their funding revoked. To the best of my knowledge, no university has ever had their funding revoked. But then again, it is a pretty big stick that the Department of Education has at their disposal. So no one wants to get even close. So they are trying to comply with this law. So the Obama administration very famously put out what is now called the Dear Colleagues letter. That is hyperlinked in the description below. This letter was, as it suggests, a letter. It was a fairly lengthy letter. I forget exactly how lengthy it was, 14 pages, 17 pages, you can check. But it was just a letter that was written, and it starts with the term Dear Colleagues, which is how it got the nomenclature Dear Colleagues letter. And it says, essentially in so many words, and this is how it has been understood, that when it comes to sex-based discrimination as it relates to sexual allegations from one student to another, we must make sure that we are not having an environment in which people are being sexually oppressed, sexually assaulted, sexually discriminated against. And you need to do more to do this. And it has manifested itself in such a way that the standard of evidence that is used by pretty much every college when it comes to student-on-student sexual harassment, because that is the context in where Title IX, by far and away, comes up today. Obviously, there are still issues with sports. Obviously, there's still issues with faculty-based harassment. But as you might expect, the vast majority of Title IX issues that exist right now are student-on-student issues. And so when we talk about Title IX, we usually are talking in that context. And the way this has manifested itself is, first, that we adopt a preponderance of the evidence standard. So that's 50.1%, more likely than not. So just more than even. So just more than even. The universities have typically not required live testimony. They have typically not allowed the person accused to call their accuser and ask questions. If they do, the questions have to be vetted in advance and approved by the people asking the questions, who are typically some combination of fellow students and or faculty members. It depends how it's construed, but they're not professional lawyers. They're not professional judges. They are some combination of faculty and students, and they're the ones that get to decide what questions will and will not be asked, if any questions are all. There's no process to compel witnesses. There's basically, if it sounds suspiciously like there's no due process at all, that's kind of because there is. And on a 50.1% standard, when the person who's accused can't call their accuser, can't ask for any witnesses, as you might expect, in a lot of these cases, the person who is accused is being thrown out, because they can't possibly make the burden that they have to make under that standard. If we have a 50.1% standard, if both people are admitting to the underlying act, which is typically what we're talking about, if both people say, yeah, we had sex, and one person says it wasn't consensual and the other person says it wasn't, well, you're pretty much there. On a 50.1% standard, you're kind of there. So this has been the problem. So the Trump administration has been working on this for a while. They've been working on this for a while. And unlike the Obama administration, which did this through the Dear Colleagues letter, which was the 17-page letter that they just wrote out with no particular authority, they just wrote it. There was no rulemaking process behind it. The Trump administration has revised this letter through a formal rulemaking process. They actually underwent formal rulemaking. And so there has been the proposed rule, there have been comments to the proposed rule, all that good stuff has been going on for 2 years, 2.5 years, something like that. It's been going on for a little bit. And because formal rulemaking takes time, and the Department of Education has come out with its formal rule. And its formal rule is in the Federal Register. It's 530 pages in a 3-column format, because that's how they write things in the Federal Register. Don't ask me why, they just do. It's 530 pages with 3 columns per page. Very annoying. The first 30 pages of it are essentially the rule and the explanations thereof, and the remaining 500 pages of it are essentially the explanations and response to all the comments that they got. Because as part of formal rulemaking, there's a notice and comment period. People can send in formal comments, and the U.S. government's under obligation to consider these. Now, I have to say that a lot of these times, the response and consideration leaves a lot to be desired. It's done in a very summary way. It's done not with particular attention to any particular comments. It's done very simply, if you like, very dismissively, in my view. Well, the Trump administration and Betsy DeVos didn't do that. They spent 500 pages responding to all the questions. Well, I don't know all. I can't say it for certain, but it certainly seems like it. They spent 500 pages responding to many of the questions that they got from various people, whether those people were victims or people who had been accused, whether those people were, civil rights people, they were concerned about women's violence. All the people had a right to comment, and they spent 500 pages responding to those comments in extreme detail. If you'd like to read those 500 pages of comments, you can. I have given you a link in the description below to the actual Federal Register notice, and you can read all 530 pages of it to your heart's content. But we're not going to do that. We're going to read the first 30 pages or so, and we're going to read it in HTML format, because it's a lot easier. So we're going to read it in the HTML format where we have one single column page, as opposed to the Federal Register notice. So we're reading the official notice. We're reading it from the federalregister.gov website, but we're reading it in HTML so that we don't have to deal with going up and down 3 columns of pages. Okay, great. So now we're going to read the thing. All right. So the first thing that you should probably know is that it's going into effect August the 14th, 2020, which more or less is the date traditionally for the first day of classes at most universities, give or take. Universities are not on a consistent scheme, but more or less, this is the first day of the fall semester. We have a lot of universities in the United States, so broadly. All right, let's read this thing and comment and understand. Enacted in 1972, Title IX prohibits discrimination on the basis of sex in education programs and activities that receive financial federal assistance. I read you that earlier. I read you the entirety of the law. It was pretty short. In the 1979 opinion of Kenyon versus University of Chicago, the Supreme Court stated that the objectives of Title IX are twofold. First, to avoid the use of federal resources to support discriminatory practices, and second, to provide individual citizens effective protection against those practices. Perfectly fine. The United States federal government has an obvious interest in civil rights, has an obvious interest in promoting education, has an obvious interest in guaranteeing to the states a Republican form of government, so it wants to use its biggest weapon it has, money, to leverage this. Makes sense. The United States Department of Education, either the department or we, may issue rules effectuating the dual purposes of Title IX. We refer herein to Title IX's prohibition of sex discrimination and purposes described by the Supreme Court as Title IX's non-discrimination mandate. The department's predecessor, the Department of Health, Education, and Welfare, first promulgated regulations under Title IX effective in 1975. Those regulations reinforced Title IX's non-discrimination mandate, addressing prohibition of sex discrimination in hiring, admissions, athletic, and other aspects of recipients' education programs or activities. So this was the initial focus of it. In women's sports in particular, it seems to me, but regardless, they focused on hiring, admission, athletics. That was what they were first talking about. The 1975 regulations also required recipients to designate an employee to coordinate the recipient's efforts to comply with Title IX, which fair enough because they're, significant, and to adopt and publish grievance procedures providing for prompt and equitable resolution of complaints that a recipient is being discriminated on the basis of sex. When the predecessor agency issued its regulations in 1975, the federal courts had not yet addressed recipients' Title IX obligations with respect to sexual harassment as a form of sexual discrimination. In the decades since the predecessor agency issued the 1975 regulations, the department has not promulgated any Title IX regulations to address sexual harassment as a form of discrimination. So we didn't address any. We haven't issued any regulations on this. We've been doing it sort of ad hoc, which is just as good a reason to have regulations as any. It's been a while. Beginning in 1997, the department addressed the subject through a series of guidance documents. Most notably, the 2001 guidance, which revised similar guidance issued in 1997, the withdrawn Dear Colleagues letter, the withdrawn Q&A, and the 2007 Q&A. So yes, we've been doing this on an ad hoc basis through these letters, Dear Colleague letters. This is not ideal, but this is what we were doing before. Not great. The department understands the agency's guidance is not intended to represent a legal obligation, which of course it can't be. It can't be a legal obligation because it's not adopted through formal rulemaking, formal process. If it's a statute or it's a regulation, it has the force of law. Random memos issued by whomever do not have the force of law, as it applies to third parties. If there's someone within the Department of Education, it would. But to random third parties, no. But then again, it's the Department of Education, and they've said, we'd really like you to do X, and they have this really big stick. So do you, if you're a college administrator, do you want to A, have the fight when your funding is on the line, or B, just do what they say in the memo? Just do what they say in the memo was the answer to that question. However, we also acknowledge in part that because the Title IX statute and the department issuing regulations have, until these final regulations, not addressed sexual harassment, recipients and the department have relied upon the guidance to set about expectations of how they should respond. In lieu of anything else, why not? You can't really fully blame the administrators. We don't know what to do. There are no formal rules on this, but there's some memos. Well, in lack of anything else, we'll listen to the memos. Okay. These final regulations, for the first time, impose legally binding rules on the recipients with respect to responding to sexual harassment. So now we have actual rules that have actual force of law. That's nice. That went through an actual rulemaking process, notice and comment, a process that if we don't at least accept, we at least understand. Random memos, I don't even understand. So whether or not you think rulemaking is good, at least we accept it as valid. The nature of these legal obligations imposed under the regulations is some way similar and some ways different to those approached in the guidance, as you would reasonably expect. They would both, every time they've issued the guidance ever, it's always been in some respect validating, in some respect modifying. So these rules will be no different. They are in some respect modifying, in some respect adopting. But whatever we said before, it doesn't matter because we have an actual final rule with actual force of law. So you can actually ignore all those memos. Thank God, and just do what this says. Isn't it so much easier? It's so much easier. Thank the Lord. These similarities and differences are explained throughout this preamble, including the adoption and adaptation of the Supreme Court's framework to sexual harassment and the rule of due process and grievance process section of the preamble. The preamble is fairly long. It's an executive summary. I think the executive summary goes on for like 30 pages. But then again, it's an executive summary to 530 pages, so yeah. Prior to the final regulations, the Department's last policy on Title IX sexual harassment was the withdrawn 2011 Dear Colleague letter. The Department of Education had formally withdrew it, I don't remember, like a year ago or something like that. Not that it mattered, because, again, for two things. First of all, the administrators, for better or worse, understood it. And again, in lack of anything else, what are you going to do? So yeah, you can withdraw the letter, but it's like, well, we don't have anything else to go on, so we'll go with that. So you can't fully blame the administrators for administrating the letter even when it doesn't exist anymore, because what else are they going to do? Just make something up? It's better than nothing. The 2017 question and answer, along with the 2001 guidance, represents the status quo or baseline against which these final regulations make further changes. Fair enough. However, the withdrawn letter and the issuance of the Q&A did not require or result in wholesale changes to the set of expectations responding to sexual harassment or many titled procedures and processes. The Department understands from public comments and media reports that many, if most, recipients chose not to change their Title IX processes and procedures following the withdrawal, which, again, fair enough, because what else are you going to do? Willie Czar, $5. Thank you for the channel. Thank you, Willie Czar, for your super chat and making this possible. It is appreciated. The lack of change by recipients is a reasonable response to the following facts. Guidance is not legally enforceable. The question and answer expressly stated to recipients that the question and answer was an interim, non-binding interpretation conducting rulemaking to arrive at legally binding conclusion, and both the questions and the letter relied heavily on guidance from earlier letters. Again, without anything else to work from, what else are you going to do? The Q&A, along with the guidance, and not the withdrawn letter, remain the baseline against which these final regulations make further enforcement. Whatever. Doesn't really matter. I don't know why they're saying this. It doesn't really matter. Who cares? They're just saying it. It doesn't even matter if it's true or not. It doesn't matter. But sure, we're not using the Dear Colleague letter as a baseline. We're using the 2001 guidance and the questions and answer. Sure, whatever. It doesn't really matter, but whatever. These final regulations largely address the same topics addressed in the Department's current and past guidance, of course they do, including the withdrawn guidance. Throughout this preamble, we explain points differently and similarly between the final regulations and Department's guidance. As such, decisions make clear some of Title IX's policies and procedures that recipients have put in place following that previous guidance and the withdrawn letter remain viable procedures for recipients to adopt when complying with the guidelines. I'm sure some of them do, yes. Because again, I don't even know how many universities there are in the United States. Depends how you're counting, but at least 2,000, I'd imagine. So someone somewhere is doing something in compliance with these new rules, I'm sure. Because these final regulations represent the Department's interpretation of the recipient's legally binding obligation rather than best practices, recommendations, or guidance, again, this is law, these final recommendations focus on precise legal compliance requirements governing the recipients. In many regards, as we've discussed throughout the preamble, these final regulations leave recipients the flexibility to choose to follow best practices and recommendations contained in department guidance, or similarly best practices and recommendations made by non-department sources, such as Title IX consultative forums, legal and social science scholars, victim advocacy organizations, civil libertarians, due process advocates, and experts. Yes, you can rely on a lot of these people to help you, but now that we have actual law, it's great because all these experts before were also similarly in this weird position of trying to interpret rules that don't exist. So all these consultants and things were trying to make the best they could of nothing, essentially, and all the lawyers were making the best they could of nothing. And now we have actual rules. So you may still be able to rely on some of these people, but now we have actual law that you can actually follow. So some of these people may be able to help you, but only if they comply with the law, which we're now going to tell you what that is for the first time ever. That's very helpful. Based on extensive review of the critical issues addressed in the rulemaking, the department has determined that the current regulations, what current regulations, they don't exist, but whatever, do not provide clear direction for how recipients must respond to allegation of sexual harassment because current regulations do not reference sexual harassment at all. Yeah. Similarly, the department has determined that department guidance is insufficient to provide clear direction on the subject because it's not legally enforceable, has created confusion and uncertainty, yes it has not adequately advised recipients as to how to uphold Title IX's non-discrimination mandate while at the same time meeting requirements of constitutional due process and fundamental fairness. Fair enough. First of all, some of these schools are public schools, so that comes with its own set of constitutional guarantees. And because Title IX is itself a law, the due process issues that apply when it's private universities, I don't have time to get into on any level. But it doesn't matter. It doesn't matter if there were due process guarantees before that will apply. I don't know, nor do I care, because I don't have to answer those questions anymore. Yay. Now, even the private universities have to do this because, again, even though they're private universities, it's a condition of them receiving federal money, including grants, scholarships, federal aid of any kind. So I suppose if there's a university out there that doesn't want to have any federal aid of any kind or accept any federal grants or anything, then sure, you can do whatever the heck you want. If there's some university out there, but no one does that because students have to get, loans from somewhere, and the Department of Education obviously offers massive loans. So they're not going to do that. So yeah, everyone everywhere has to apply to this unless you want to be how much is your virtue worth to you, I guess, left-leaning people, or apologize, that's a little unfair to the left. How much is your virtue with you, people who want to just have witch trials? If it's worth enough to you, I guess you can have a university without any federal finances. Good luck with that plan. Therefore, the department issues these final regulations addressing sexual harassment to better align to the department's Title IX regulations with text and purpose to Title IX, the U.S. Constitution, Supreme Court precedent, and other case law, and to address practical challenges facing students, employees, and recipients with respect to sexual harassment allegations in the educational programs and activities. The final regulations define and apply the following terms, as discussed in Section 1.6.30 definitions of the preamble. So we have defined some terms. Yay, that's helpful. What are these defined terms? Actual knowledge, complainant, elementary and secondary schools, formal complaint, post-secondary institution, respondent, sexual harassment, and supportive measures. Each term having a specific meaning under these final regulations. For clarity of understanding when receiving the preamble, complainant means any individual who is alleged to be the victim of sexual harassment, and respondent means any individual who is reported to be the perpetrator of sexual harassment. Seems pretty clear. A person may be a complainant or respondent even where no formal complaint has been filed and no grievance process is pending. Okay, that's interesting. So a person can be a complainant or a respondent even where no complaint has been filed and no grievance process is pending. It's an interesting idea. Okay. A formal complaint is a document that initiates the grievance process, but a formal complaint is not required in order for a recipient to have actual knowledge of sexual harassment. That would make sense. Of course, you can have actual knowledge without the complaint. Or allegations of sexual harassment. Again, you wouldn't need to have a formal complaint to know that there are allegations of sexual harassment. That activates a legal obligation to respond promptly, including by offering supportive measures to a complainant. So yes, they're clarifying here that just because a person hasn't filed a formal complaint doesn't mean that the university isn't under an obligation to do something about it. So if the university comes in, and they're going to explain this more, I'm sure, but if a university comes into knowledge that there is sexual harassment or sexual assaults or whatever occurring, even if no one filed a complaint, they have an obligation to do something about it, which to my mind makes total sense. If you come into knowledge of things that are happening, just because a person doesn't want to come forward, you might want to do something about the problem. So you have an obligation even if no complaint has been made. Okay, that makes sense. Let's read on. References in this preamble to complainant or respondent or other individual with respect to exercise of rights under Title IX should be understood to include situations in which a parent or guardian has the legal right to act on behalf of the individual. So if it is a minor who is attending university, which occasionally happens, then that applies there too, no problem. Alleged victims of sexual harassment often have options to pursue legal action through civil litigation or pressing criminal charges. Sure, they might be able to sue personally. They might be able to get the police involved. Yes. Title IX does not replace civil or criminal justice systems. Yes, it doesn't. Right. So you still can sue. Now you're a victim of sexual harassment. You have at least 3 options. You might be able to go criminal. You might be able to go civil and sue, and you also have Title IX remedies. Now, Title IX remedies present some ability for the university to act in ensuring the safety of the campus, and can, in some situations, be faster and provide more remedies. But you have these options. It's not supplanting those options. You still can go criminal. You still can go civil. You can sue if you want to. The final regulations require recipients to offer supportive measures to every complainant, irrespective of whether the complainant files a formal complaint. Recipients may not treat a respondent as responsible for sexual harassment without providing due process. Well, I'm sure they're going to get more into what that looks like, but that's good news. So you might have an obligation to offer support to the person who is harmed, regardless. But you can't treat a respondent or the other guy as responsible without due process. So you actually have to give them due process. So whatever else you're going to do, you can't do something against this person without due process. When a recipient determines a respondent to be responsible for sexual harassment after a fair grievance procedure that gives clear procedural rights to both parties, the recipient must provide remedies to the complainant. Okay, fine. These final regulations are premised on setting forth clear legal obligations that require recipients to promptly respond to individuals who are alleged to be victims of sexual harassment by offering supportive measures, follow a fair grievance process to resolve sexual harassment allegations when a complainant requests investigation or a Title IX coordinator decides on the recipient's behalf that an investigation is necessary. So the Title IX coordinator can do an investigation without a complaint, it looks like, but still due process, and provide remedies to victims of sexual harassment. Regarding sexual harassment, the final regulations define conduct that constitutes sexual harassment for Title IX purposes. We are going to define what constitutes sexual harassment. That's good news, because a whole host of content could be harassment depending on what we want. A guy asking a girl to go out could, in theory, be sexual harassment. It's obviously sexual in nature. Well, yeah, it's purportedly sexual in nature, and depending on whatever, it might be harassment. So, maybe a blown joke, maybe whatever. So there's a whole host of things, and people are infinitely sensitive, right? There's someone sensitive enough to think being asked out enough is harassment. So we have that on one continuum. And then, of course, on the other continuum is full-blown sexual assault of criminal nature. So we're going to define what things in this continuum qualify as sexual harassment. That's good news. Specify the conditions that activate a recipient's obligation to respond to allegations of sexual harassment and impose a general standard for sufficiency of response. What does a sufficient response look like? Cool. And specify requirements that such a response must include, such as ordering a supportive measure in response to a report or a formal complaint of sexual harassment. Specify conditions that require a recipient to initiate a grievance process to initiate and adjudicate allegations of sexual harassment. So we're going to specify conditions that are required to initiate a formal process. So there are some things that must occur in order to engage in an official process. So you can make any kind of report you want, but to engage in the formal process, there has to be some predicates that apply. Cool. Establish procedural due process protections that must be incorporated into the recipient's grievance process to ensure a fair and factual determination when a recipient investigates and adjudicates a formal complaint of sexual harassment. Additionally, the final regulations affirm the Department's Office of Civil Rights may require recipients to take remedial action for discriminating on the basis of sex or otherwise violating the Department's regulations implementing Title IX, consistent with law. So the Office of Civil Rights may also come after you if you're not doing a good job. clarifying that responding to any claim of sexual discrimination under Title IX, recipients are not required to deprive an individual of rights under the U.S. Constitution. So you are not, in fact, required to deprive someone of rights. That's good news. Acknowledge the intersection of Title IX, Title VII, which also deals with sex, and federal FRIFRA, which deals with federal records of colleges. So basically, FERPA. I think it's the Federal Education Records Protection Act, I think is the acronym. But basically, it says that records of an individual are private records on the individual, and they are kept confidential. So education records belong to the person who's getting the education. So how to acknowledge these things, right? How does Title IX interact with Title VII, which also deals with sex-based discrimination in employment, deal with federal records of colleges, as well as legal rights of parents and guardians to act on behalf of individuals with respect to Title IX, which again, in terms of federal education records, is notable because again, the records belong to the student regardless of whether or not they have a guardian or not. So interesting little thing. Update the requirements for recipients to designate a Title IX coordinator. Disseminate the recipient's non-discrimination policy and Title IX coordinator's contact information. And notify students, employers, and others of the recipient's grievance processes for handling reports and complaints of sex discrimination, including sexual harassment. Eliminating the requirement that religious institutions submit a written statement to the Assistant Secretary of Civil Rights to qualify for Title IX religious exemption. I don't know anything about what that is talking about in terms of religious schools. I didn't know that there was a religious exemption or how those apply. So maybe we'll all become educated. I didn't realize that religious schools might have had a carve out. And expressly prohibit retaliation against individuals for exercising Title IX. And so now we go through the history of this a little bit. On November the 29th, 2018, so it's been a year and a half, the Secretary published a notice of proposed rulemaking for the Federal Register. Final regulations contained from this notice, and these changes are fully explained in analysis of comment and changes in other sections. Yeah, so they also have to explain any changes they made between the proposed rules and the final rules, in addition to response for comments. So again, that goes into why there's 500 pages of commentary. Any changes they made from the proposed rules to now and all the responses to the comments. So they explain those in great detail. Throughout the preamble, the department uses terms like institution of higher education interchangeably with post-secondary institutions. Sure. The department uses the phrase elementary and secondary schools interchangeably with local education agencies. Fine. Throughout the preamble, the department refers to Title IX of the Education Act as amended, to the Individuals with Disabilities Act as IDEA, nice, to Section 504 of the Rehabilitation Act as Section 504, to Americans with Disabilities Act as ADA, to Title VI of the Civil Rights Act as Title VI, to Title VII of the Civil Rights Act as Title VII, to Section 444 of the General Education Provisions, which commonly referred to as Federal Education Rights and Privacy Act as FRIFRA, and to Jim Cleary disclosure of campus policies as the Cleary Act, which does mandatory disclosures for serious incidents that colleges are required to make notices of, and Violence Against Women's Reauthorization Act as the VAWA. So there are a lot of different laws that are interacting in this, and you can see why it takes a while to write these things, because it becomes a headache, right? The department uses the phrase Title IX sexual harassment to refer to conduct defined in this code to be sexual harassment, as well as conditions described therein that require the recipient to sexual harassment. When the department uses the term victim or survivor or perpetrator to discuss these final regulations, the department assumes that a reliable process, namely the grievance process, has resulted in a determination of responsibility, meaning the recipient has found a person responsible. Throughout the preamble, the department references and summarizes statistics, data, research, and studies that commenters submitted. We have actual numbers. That's helpful. The department's reference to or summary of these items, however, does not speak to their levels of accuracy. Whether specifically cited or not, we consider all relevant information significant to us in determination of the analysis. So yes, they might cite statistics, but that doesn't inherently mean that they are accurate, but it doesn't mean they're not. It just means they are what they are. The department references statistics, data, research, and studies throughout. Such references does not indicate that it's independently determined that each item is accurate. which is more of a CYA, cover your butt kind of point. I'm reasonably confident they read everything, but they are just taking the note to say we're not guaranteeing the accuracy. They presumably wouldn't be citing it if they didn't think it was accurate, but they're covering their butt by saying we're not guaranteeing its accuracy because it was produced by someone else. And so we're not going to be able to guarantee its accuracy. We tried, but we're not guaranteeing it. Fair enough. Many commentators reference the impact of sexual harassment or proposed rules on individuals who belong to or identify with certain demographic groups, and use a variety of acronyms or phrases to describe these individuals. Yes, this is always fun. For example, various commentators refer to LGBT or LGBTQ and persons of colors or racial minorities. For consistency, throughout this preamble, we use the acronym LGBTQ when recognizing that other terminology may be used or preferred. We have picked one. This is what we're going with. We're going with LGBTQ. Other people may prefer other things, but we have to have a term. We're going with this. Fine. And our use of LGBTQ should be understood to include lesbian, gay, bisexual, transgender, queer, questioning, asexual, intersectional, non-binary, and other sexual orientations or gender identity communities. Very progressive. We use the phrase persons of color to refer to individuals whose race or ethnicity is not white or Caucasian. I am not a person of color. It's very sad. We emphasize that every person, regardless of demographics or personal characteristics or identity, is entitled to the same procedures against sexual harassment, and that every individual should be treated with equal dignity and respect. So just because you're a member of a certain group does not mean you get more, and just because you're not doesn't mean you get less. Everyone gets the same. Equality. Equality is nice, yes. Finally, several provisions in the notice of proposed rulemaking have been renumbered in file regulation. We did renumber things. Yes. We moved things around. It's fine. In response to commentators who asked for clarification as to whether the definitions in the proposed rule apply to a term in a specific regulatory provision, some of the regulatory provisions specifically refer to a term as defined in that to provide additional clarity. Notwithstanding these points of additional clarification, the definitions in the section apply entirely to the section of 34 CFR 106. So definitions apply to the entire thing. Fine. For consistency, references in the preamble are provisions as numbered in the final and not proposed regulations. So yes, for the sake of consistency, we are going to refer to things as they are now numbered, regardless of how they've been numbered in the past. We don't want to confuse everyone. We're using the current numbering. Fine. All right, adoption and adaptation of the Supreme Court's framework. So now that we've gotten all that wonderful preamble out of the way of how we came to this wonderful, wonderful place, we need to talk a little bit more about how we have adopted and applied the Supreme Court's framework to this. Now, presumably, the Department of Education could use other frameworks because the Supreme Court is interpreting things in a particular light. And again, there was no guidance as to Title IX. So they couldn't have been interpreting Title IX, presumably. So they could use this or not, but it's Supreme Court, so it's a reasonable thing to use, right? It's been vetted in one context. We're going to adopt it and use it. Fine. 7 years after the passage of Title IX, the Supreme Court held in Cannon versus Chicago that held a judicially implied private right of action exists on Title IX. So yes, you can sue for yourself for Title IX if you're so inclined. 13 years after that, in Franklin versus Gwinnett County Public Schools, the Supreme Court held money damages are an available remedy in a private lawsuit, so you can get money. The Cannon Court explained that Title IX has two primary functions: avoiding the use of federal funds to avoid discriminatory practice and providing individuals with effective protection. These two purposes are enforced by administrative agencies that disperse federal financial recipients and to courts in private litigation. In deciding whether to recognize the judicially implied private course of action, the Cannon Court considered whether doing so would conflict with administrative enforcement. The Cannon Court concluded that far from conflicting with it, judicial enforcement will complement enforcement because some of these Title IX violations may lend themselves to administrative remedy of terminating financial assistance, while others might lend themselves to additional remedy and private litigation. So yes, there are multiple avenues. It's not a problem. No problem. Great. In Franklin, the Supreme Court acknowledged that sexual harassment and sexual abuse of a student by a teacher may mean the school engaged in intentional sexual discrimination. So teacher on student, that's Franklin. The Franklin Court held that money damages is available as a private lawsuit under Title IX, reasoning that even though Title IX is a spending clause statute, schools have been noticed that intentional sex discrimination is prohibited under Title IX. And again, as a general proposition, as a general proposition, when the government is spending money, it can attach things to those. Limitations apply, but they can. So yes, this is part of the spending power. We want to spend money in a particular way, and here's some conditions. Okay. In 1998, 6 years after Franklin, in Gesber versus Largo Vista Independent School District, the Supreme Court analyzed the conditions under which a school district will be liable for money damages for an employee sexually harassing a student. The Geisberg court began its analysis by stating that while Franklin acknowledged a school employee sexually harassing a student may constitute the school itself committing the intentional discrimination on the basis of sex, it was necessary to craft standards to define in the contours of the liability. What are we talking about exactly? Yes. The Geisberg court held that where a school has actual knowledge of an employee sexually harassing a student, but responds with deliberate indifference to knowledge, it doesn't care, the school itself has engaged in discrimination. So that the school choosing to turn a blind eye with actual knowledge, that is where it trips. That makes sense. Subjecting the school to money damages. The following year, in 1999, in Davis versus Monroe County Board of Education, the Supreme Court held that where sexual harassment is compared by a peer. So now we're talking about student on student action. Okay, so this is where student on student action comes. In 1999, in Davis versus Monroe, the Supreme Court held that where sexual harassment is committed by a peer, that is a fellow student, rather than by an employee, the same standard of actual knowledge and deliberate indifference apply. Again, the school has to actually know about it. Fine. The Davis court additionally crafted a definition of when sex-based discrimination became sexual harassment, defined the conduct as so severe, pervasive, and objectively offensive that it denies victim equal access to education. We're going to see that language again in these regulations, and that's where it comes from. So in that case, where this whole thing was recognized, this peer-on-peer sexual harassment, you have to have actual knowledge. Actual knowledge of what? Actual knowledge of conduct that is so severe, pervasive, and objectively offensive that denies equal protection. That was what the Supreme Court said in a Title IX case dealing with student-on-student discrimination. So as is going to be adopted in the formal rulemaking, you're going to see that language again. And that's where it comes from. Makes sense to use what the Supreme Court came up with? Sure. Other options may have been available. I want to state that again. Other options may have been available. But the Supreme Court has said this in the same context. And so, although other options may be available for a variety of administrative reasons, they will say we want to just adopt the same thing the Supreme Court did. Cool. I mean, it's already been done and vetted, so that makes it easier, I suppose. The Supreme Court in Gesber and Davis built upon Supreme Court previous Title IX decisions in Cannon and Franklin to establish a three-part framework for establishing or describing when a school's response to sexual harassment continues to school itself for discrimination. By the way, for those of you who are watching, the 26 of you who are currently watching, thank you very much. And as always, if you wish to financially support the channel, it is always appreciated. I'm just guessing that this video may be demonetized because he's covering, sketchy, scary topics. So, the three-part of the framework are conditions must exist that trigger the school's response obligations, actual harassment, and school's actual knowledge, and deliberate indifference liability standard, evaluating the sufficiency of the school's response. We hear and refer to this as a Geisberg-Davis framework because it was established in those two cases, consisting of a definition of actual harassment, the school's actual knowledge, and deliberate indifference. Actual harassment, actual knowledge, actual indifference. Fine. The Gesber-Davis framework is an appropriate starting point for ensuring the regulations recognize the conditions under which the school's response to sexual harassment violates Title IX. Sure. When available remedy is money damages in private litigation or termination of federal financial assistance in administrative enforcement, the department's regulations must acknowledge when a school itself commits the sex discrimination that the school has violated the Title IX. So yes, we're going to look to that framework as giving us an answer. In crafting the Gesber-Davis framework, the Supreme Court emphasized that because a private lawsuit under Title IX subjects a school to monetary damages, it was important for a court to set standards for a school's liability premised on the school's knowledge and deliberate choice to permit the sexual harassment, analogous to the way Title IX school statute provides the school's federal financial assistance is terminable by the department. Only after the department first advises the school of the violation, attempts to secure voluntary compliance, and the school refuses to come into compliance. Nothing in the Gesber or Davis framework purports to restrict the framework to only private lawsuits for monetary damages. So they're pointing out that these statutes or these court decisions were decided in the context of private action for private damages, a private person suing, and these were the standards that they were supposed to raise. So it could be that these standards would be for that context, and in other contexts, something else. So again, they might have been able to do something different here, but they're pointing out that nothing in the decisions seems to indicate that it's explicitly limited to those contexts. Not that you would really expect it to be. The Supreme Court tends to like things to like leave their options open. So they're not very likely, if they don't have to say for this context and this context alone. It does happen, but most of the time they leave themselves open so they can read themselves by analogy in other contexts. So it could be that this is only private lawsuit, private party, and only them. And here we have a different situation. We have a school that's about to engage in a Title IX investigation. And what could they do? So there might be a different standard or not, but there's nothing in these cases that says we can't use them. They're the best thing we have, so let's adopt those. Again, other options might have been available. This is what they went with. Neither Gesber nor Davis opined as what appropriate conditions and liability standard must or should be for administrative enforcement. They didn't impose it on us, so we have other options. The department has regulatory authority to select conditions and liability standards from those different from the framework, yes, because the department has authority to issue rules that require recipients to take administrative actions to enforce the mandate. Sure. For example, longstanding department regulations require recipients to designate an employee to coordinate efforts. To file a short $4 from Greg Polanski. Thank you very much for the super chat of the $4, Greg. It is super appreciated. I appreciate your support and helping to fund this channel. It really means a lot to me and helps the channel grow immensely. Thank you very, very much. I can't help noticing that in my super chat, in my window for live streaming, I can't help noticing that despite the $4, it says my chat revenue is 0. I'm going to try not to look into it too hard. I'm going to hope it's just not updating and not creating an actual, like I haven't, yeah, okay. Failure to do any of the foregoing does not by itself mean the school has committed sexual discrimination, but the department lawfully may enforce an administrative requirement because it has the authority to issue rules that effectuate this purpose. Presumably so, yes. Yeah, the administrative law, as we know from way too many coverages of this case, or coverage of cases, is pretty wide. The final regulations begin with this framework so that when a school itself commits sexual discrimination by subjecting its students or employees to harassment, the form of discrimination is clearly prohibited by these regulations. The government adopts a framework in these regulations by defining sexual harassment, defining actual knowledge, and describing deliberate indifference consistent with the cases. So again, we could have done something different, but we didn't. We adopted it and we've explained it or modified it or whatever. So that's fine. The department does not simply codify the framework. Under the statutory authority to issue rules to effectuate the purpose, the department reasonably expands the definition of sexual harassment, actual knowledge, and deliberate indifference standard to tailor it to the actual framework. Again, we could do different things. We could adopt it wholesale, but we've made some modifications along the way to adopt it to this framework. Fine. The department believes that by adopting the framework, it's appropriate for administrative enforcement because the adaptive conditions and liability standards reflected in the file regulations promote important policy objectives with respect to a recipient's legal obligations to respond to sexual harassment. As explained in more detail in actual knowledge and sexual harassment subsections of the law, the department believes that, including a Davis definition of sexual harassment for Title IX purposes, as severe, pervasive, and objectively offensive conduct that denies a person of equal opportunity helps ensure Title IX is enforced consistent with the First Amendment. At the same time, the department adapts Davis's framework of sexual harassment in these file regulations by also expressly including quid pro quo harassment, this for that, and sexual and Clery Act of Violence Against Women Act sex offenses. This expanded definition of sex harassment ensures that quid pro quo harassment and the Clery Act harassment offense triggers a recipient's response obligations without needing to be evaluated for severity, pervasiveness, and offensiveness or deniality of equal access, because prohibiting such conduct prevents no First Amendment concerns and such serious misconduct causes denial of educational access. Something's going on outside. Anyways, the bars are opening for the first time today in Austin. So I'm imagining some people are pretty happy. It's about to be 5 o'clock somewhere for the first time ever. So, incidentally, while I'm doing the stream relatively early, because, yeah. Under the Geisler-Davis concept of actual knowledge, adaptation of the final regulations by including notice to any recipients of the Title IX's coordinator or notice to any elementary or secondary school employee furthers the department's goals of ensuring that elementary and secondary schools respond to whatever a school employee knows of sexual harassment or allegations while respecting autonomy of students. Using the deliberate indifference standard adapted in these final regulations by specifying actions that every recipient must take in response to every actual instance of knowledge of sexual harassment ensures the recipients respond to sexual harassment by offering supportive means designed to restore or preserve a complainant's equal educational access without treating a respondent as responsible until a fair grievance process. The deliberate indifference standard achieves these aims without unnecessarily second-guessing a recipient's decision with respect to appropriate supportive measures, disciplinary sanctions, and remedies when the recipient responds to sexual harassment incidents which inherently present a factual-based circumstance. Whew. The department chooses to build on these final regulations upon the foundation established by the Supreme Court to provide consistency between the rubrics for judicial and administrative enforcement while adapting that foundation for administrative processes in a manner that achieves important policy objectives unique to sexual harassment and educational programs or activities. It also presumably, to the extent that it's not otherwise inconsistent with these guidelines, it would also mean any case that happened to be decided along those frameworks by any court would also be relevant legal authority. So it also has a benefit of adopting, essentially, to the extent not inconsistent here, because again, they could do things different here, but to the extent it's not inconsistent here, like all that case law that might exist comes along for the ride to help to do things. Now, it would technically be, I suppose, persuasive authority, not binding authority. So all that case law is technically persuasive, not binding, but again, it helps to use something that exists to flush out something you're developing. So we have something to work from. That's helpful. So there's differences between the standard guidance and the final regulations. Okay, so what are the differences? Okay, so what are the differences between the guidance that we've had and the final regulation? What are the differences that between what we used to have and what we have now? That's what we're about to get into. That's exciting. The department's guidance on schools' responses to sexual harassment recommendations conditions triggers a school response obligations and liability standard that differs significantly from the way that Geisler-Davis framework and the approach taken in the final regulations. With respect to the three-part framework, the department's guidance recommends a broader definition of actual sexual harassment, a constructive notice condition. So there's situations in which you will have notice. So actual notice and constructive notice, okay. And standard closer to a strict liability than deliberate indifference. Okay, so in some ways it looks like they're making things tighter. So rather than just deliberate indifference, we're getting closer. It looks like we're not going to adopt it, but it looks like we're getting closer to strict liability. Strict liability means we don't care if you know or not, you're liable. And you use that for the example where that comes up is particularly dangerous activities. So a good example might be a fireworks factory. If you're a fireworks factory and stuff happens, like your fireworks go off, we don't care how careful you are. We don't care how many regulations you filed. We don't care how diligent you were. It doesn't matter. So strict liability. You're liable because you're engaged in the activity. If you keep lions in your backyard, we don't care how careful you are. Strict liability. So we are getting closer to that by saying we don't care what you knew or didn't know. If a person's harassed, strict liability. Now they're not adopting it, but they say they're getting closer. So that's interesting. The department's 1997 guidance used a definition of sexual harassment that described sexual harassing conduct, which can include unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or sexual conduct of a sexual nature by an employee or another student or a third party, which seems a little overbroad to me, because sexual advances, again, that could just be a person asking a person out would technically be a sexual advance, I suppose. The 1997 guidance recommends that students take action on the basis of constructive knowledge rather than actual knowledge. Instead of deliberate indifference, the 1997 standard indicated the department would find a school in violation where the school failed to stop the harassment or prevent reinforcement. The 2001 guidance acknowledged the time period between the department issuing the 97 guidance and 2001. The Supreme Court's Gesber and Davis decisions addressed the school subject responses to Title IX. So there was some Supreme Court decisions that happened. The 2001 guidance reasoned that because those Supreme Court cases were decided in the context of private lawsuits for money damages under Title IX, the department was not obligated to adopt the same standards for enforcement, which is probably true. $10 from Fire makes me king. Thank you for explaining the cluster F of Title IX. You are most welcome. Thank you for your super chat. It is most appreciated. Thank you. Excuse me one second while I reload this page. I just have to check something out for my own knowledge. Give me 1 second. Okay. Just want to make sure the chat revenue thing was increasing. Make sure I wasn't being like shadow banned or something. All right, where was I? The 2001 guidance reasoned that because the school always receives notice of a violation, opportunity to voluntarily correct a violation, the department was not required to use the actual knowledge condition or deliberate indifference standard. And so the 2001 guidance continued the 1997's approach to constructive notice and strict liability, which again would go a long way to explaining why administrators everywhere freak out the way they do. And it would go a long way to explaining why they were doing things the way they do. If you have strict liability, you wouldn't do anything different as an administrator. You would absolutely freak the F out if you had strict liability. So if they had strict liability, it totally makes sense why they would do these things. Yeah, because The 2001 guidance nonetheless asserts consistency between the judicial and administrative rubrics was desirable with respect to a definition of sexual harassment. 2001 guidance stated a multiplicity of definitions. One for private lawsuits and another for administrative purpose would not serve the purpose of consistency between judicial and administrative enforcement. So they said it was the same standard in both places. Again, we could have a different standard, but we're going to adopt the same thing in both places for consistency, which is a reasonable choice too. The 2001 guidance asserts that Davis' definition of actual sexual harassment using different words, severe, pervasive, and objectively offensive, but was consistent with the definition of sexual harassment used in the 1997 guidance, severe, pervasive, persistent, or pervasive. The 2001 guidance proceed to describe sexual harassment as unwelcome conduct of a sexual nature, that is, severe, persistent, or pervasive, and asserts this definition was consistent with Davis' definition because the definition are conceptual descriptions intended to capture the same conduct. That is, under Title IX, the conduct must be sufficiently serious that adversely affects a student's ability to participate or benefit from the school's program. Which, I'm not exactly an expert in Title IX before the Dear Colleagues letter, but my rough understanding, both from being a college student before the Dear Colleagues letter and just in general, was that before the Dear Colleagues letter, we didn't have quite these problems. Because you had to show the severe, pervasive nature of it. And, so it was a lot different. The withdrawn 2011 Dear Colleagues letter continues to define sexual harassment as unwelcome conduct of a sexual nature and added that sexual violence is a form of sexual harassment prohibited by Title IX without defining sexual violence. The withdrawn 2011 Dear Colleague letter continued the approach from the 2001 guidance that sexual harassment must be sufficiently serious that it interferes with or limits the student's ability to participate in or benefit from the program, but omitted the description of actual offense as severe, persistent, or pervasive that had been utilized. So that was the big difference in the 2011 guidance memo. They kept the definition, but they omitted the part about it being severe, pervasive, or persistent. So any amount, all of them. And the universities did pretty much exactly what you would expect under a strict liability standard. If it no longer has to be persistent, pervasive, or severe, then they did exactly what you would expect. So the letter had the intended effect on the administrators. To the degree to which the administrators wanted to do it or not implicitly anyway, because of their political leanings, is a whole other issue. But on a purely objective basis, it's totally understandable why they did what they did. Who would do anything else? If any amount of sexual harassment is enough, and it's a strict liability standard, what would you do? Probably exactly what the administrators did. You would freak the F out. The withdrawn Dear Colleague letter continued to recommend schools act upon the constructive knowledge, which is even worse, and hold schools accountable under strict liability and deliberate indifference. So the universities did that, and that's what you saw happen. Any amount of sexual harassment will be fine. Even if you don't know about it, it's fine. You have strict liability if it's happening anywhere. If it's happening anywhere in any amount, even if you don't know about it, you're responsible for it. So what would you do? What would you do? You'd probably go on a witch hunt. Yeah. The 2017 question and answer used this definition of actual sexual harassment as described in the guidance, stating that when sexual misconduct is so severe, pervasive, or persistent or pervasive as to deny or limit an ability persistent in the program. The Q&A relied on the guidance condition of constructive notice rather than actual notice. So the Q&A is trying to take some of this back, it looks like. No wonder administrators are confused. No wonder they're confused. The Q&A is not reflecting the same thing as the guidance, and it's all because it's being done ad hoc. Although the 2017 Q&A did not expressly drop deliberate indifference versus strict liability, it directs recipients to 2001 guidance for topics not addressed in the memo, including what it means to know for a school to respond, or when a school should know or reasonably should know, which apparently is even if you don't know or shouldn't know, I guess, because that's what strict liability would be, thereby retaining a 2001 guidance reliance on constructive notice and strict liability. To the extent the department intended for schools to understand the 1997 guidance, the 2001 guidance, the withdrawn 2011 letter, or the 2017 Q&As as descriptions of legal obligations, which, again, in the lack of anything else, what else would you do? Of course you would. Of course you would. I'm sympathetic to the school administrator's position given this description, because without anything else to go by, what else would you do? If you had strict liability for anything that happened anywhere, even if you don't know about it to any degree, what would you do? What would you as a rational actor do? Probably exactly what they did. So some of these administrators may have been strongly inclined to do this anyway. So a lot of these people may have wanted to do this. And this memo gave them the excuse to do what they would have wanted to do. So this letter didn't come out of nowhere. I'm quite sure that it came from the intelligentsia of certain universities, of certain leagues, of ivory color. And I'm quite certain that it's certain things that some of them wanted, and they were quite happy to do it. But from a purely objective basis, what else would you do? You'd run like a chicken with your head cut off. So on a purely objective basis, it's a little hard to blame the administrators because in lack of anything else, what else are you going to do? As the administrator for the college, what are you going to do? As the administrator for the college, what are you going to do? You know, not great. Someone suggested sue the federal government. You could try that. But again, we've covered cases dealing with issues of Chevron, Auer, Brand X. We've covered the administrative state. So do you really want to fight that? Do you really want to be the guy to fight that battle? Do you really want to take them on when so much is on the line? Apparently the answer to that question was no. So, yeah. To the extent the department intended for schools to understand, okay, the department believes that sexual harassment affects the equal access to education that Title IX is designed to protect, and the problem warrants legally binding regulations addressing sexual harassment as a form of sex discrimination instead of mere guidance documents, which are not binding and do not have the force of law, but still manage to scare the ever-living crap out of anyone anyway. The starting place for describing these obligations is the adoption of the Gesber-Davis framework, because the framework describes when sexual harassment constitutes a school itself discriminating on the basis of Title IX. At the same time, the department adopts the test and does some other stuff. The department's adoption of this test achieved important policy objectives that rise in the context of schools' response to reports, allegations, or incidents of sexual harassment in schools' education program or activity, including respect for freedom of speech and academic freedom, response for complainants' autonomy, protection of complainants' equal educational access, while respecting decisions of state and local educators to make appropriate supportive measures, remedies, and disciplinary standards consistent with constitutional due process and fundamental fairness and clear legal obligations that enable robust administration and enforcement of the violations. The adoption of the framework and these final regulations do not codify the department's guidance, yet provide recipients with flexibility subject to legal requirements in these regulations to respond to a greater range of misconduct, operate on condition of constructive notice, or respond under strict liability standard if the recipient chooses to adopt these guidelines-based standards for itself, or the recipient is required by state or other law to adopt these standards. Fine. All right, so then we have some definitions of stuff. The way in which these final regulations differ from the guidance in defining the actual sexual harassment is returning to the 2011's guidance premise that consistent definition is used in both judicial and administrative enforcement is appropriate. Despite the 2011's guidance asserting the different words from the Davis definition of actual harassment did not result in inconsistent definitions, the department has reconsidered that assertion because the assertion did not bear out on time. So the department said we use different words, but they mean the same thing, and it led to problems. If you want the same words that mean the same things, use the same words. So they want to use the same words. That makes more sense. The final regulations thus use as one of three categories that constitute sexual harassment the Davis's court phrasing verbatim. So we have actual language from actual court verbatim. So unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that effectively denies a person's equal access to education. We just adopted verbatim. Great. The department chooses to return to the premise expressed in the 2001 guidance. The department has an interest in providing recipients with consistency and simplicity, understanding what sexual harassment is for, which a school must take responsive action. A multiplicity of definitions will not serve this purpose. In addition to using this definition verbatim, that is conduct that's so severe, pervasive, and objectively offensive that it effectively denies a person equal access. The proposed regulations define the sexual harassment to also include sexual assault as defined in the Clery Act. In the final regulations, the department retains reference to sexual assault under the Clery Act, additionally incorporates definitions of dating violence, domestic violence, and stalking in the Clery Act as amended by law. So we are adopting these things from other laws here because they've already been defined, adjudicated. Again, we are bringing along all that case law for the right, at least as persuasive authority. So we're going to use the stuff that's already been done before. So we're going to adopt all those definitions. They've already been decided by courts. They've already had case law on it. We already know what these things mean. We can go forward with our lives. So we can take all that stuff, incorporate it. All that case law becomes at least persuasive authority for what we're doing here. It makes our lives a lot more defined. Incorporating the 4 Clery Act Violence Against Women Act offenses clarifies that sexual harassment includes a single instance of sexual assault, dating violence, domestic violence, or stalking. That makes sense. And again, these things have legal definitions, right? Such incorporation is consistent with the Supreme Court's observation in Davis that a single instance of a sufficiently severe harassment on the basis may have the effect of denying equal opportunity. I think we're all behind this idea, right? One sexual assault is enough. That makes sense. However, the department's inclusion of sexual assault, dating violence, domestic violence, and stalking in these definitions of sexual harassment, without requiring those sexual elements to meet the Davis elements of severe, pervasive, and objective, again, they don't have to be severe or pervasive or objective because they are already on their own terms severe and objective, right? They're already defined by law, so we don't have to do it again. Appropriately guards against, for instance, some sexual assaults or incidents of dating violence or domestic violence being covered under Title IX, while other sexual assaults or incidents are not deemed to be pervasive enough. So we're not going to deal with that problem. Fine. Similarly, this approach guards against pattern of sex-based stalking deemed not severe even though the pattern is pervasive. So stalking, bad. Stalking, again, also has a legally precise definition. So it's something that we understand. Just because you are following someone around doesn't make it stalking. Stalking has contours and case law. Such incorporation also provides consistency and clarity with respect to the intersection of these various laws. So we're trying to bring these all into harmony, which makes sense. The final regulations retain the proposed definition of quid pro quo harassment in the definition. The department recognized quid pro quo harassment in its guidelines and cited court cases. So yes, quid pro quo harassment, give me sex in exchange for whatever. That is bad. The Honorable Janet Napolitano, president of the University of California, who is former governor and attorney general of Arizona and former United States Secretary of Homeland Security, observed that under the department's guidelines, recipients had to grapple with a broad continuum of conduct from offensive statements to gang sexual assaults. So yes, Under the prior guidance, all these things were merged in an undifferentiated way, not particularly helpful. And the department's guidance, especially after the 2001 guidance was supplemented and altered by the 2011 Dear Colleagues letters, caused recipients uncertainty and confusion about how to appropriately comply. By utilizing precise definitions of conduct that constitute harassment, the department aims to reduce the uncertainty and confusion for recipients, students, and employees while ensuring conduct that jeopardizes equal opportunity remains conduct to which a recipient must respond. Some commentators requested the department more closely align its definition of actionable sexual harassment with the definition the Supreme Court uses in the context of discrimination because of sex under the workplace in Title VII. Okay, so Title VII deals with employment. Title IX deals with education, and both prohibit discrimination on the basis of sex. And we've definitely seen the U.S. Supreme Court, and I'm pretty confident we'll see again this term because this has come up again this term. We have seen the Supreme Court use language from one onto the other. They both prohibit discrimination on the basis of sex, one in employment and one in education. But case law from one often winds up being case law the other eventually. They steal from each other quite frequently. And so some of the commentators said, okay, there's a definition under Title VII for employment-based context that might be better to use. Again, we might be free to do anything. And the idea, again, of using a definition in Title VII in a Title IX context totally makes sense. Because, again, they do it not infrequently, where one reads on the other. So, perfectly reasonable suggestion. Specifically, the commentators urged the department to use a definition of sexual harassment that's severe or pervasive, because the definition is used under Title VII. So Title VII, severe or pervasive, not both. And the 1997 guidance and 2001 guidance, under which Title VII case law used the definitions severe, persistent, or pervasive. Okay. However, in Davis, a case concerning sexual harassment of a fifth grade student by another student, the Supreme Court did not adopt this definition of sexual harassment for use under Title IX, defining sexual harassment as severe, pervasive, and offensive. So in Title VII, so the statutes are different. They are different. They're directed the same thing, but they're different and they're directed differently and against different targets. So in the context of discrimination on the basis of sex and employment, any one of them will do. But in the Supreme Court has previously said, again, we don't necessarily have to adopt it here, but we're going to, that we need all three in the case of education. Okay, so we need all three. So we're gonna stick with and, not or, all three. The department is persuaded by the Supreme Court's reasoning that elementary and secondary schools are unlike adult workplaces, and children may regularly interact in manners that would be inappropriate for adults. Fair. These final regulations are also consistent with the Equal Access Act, requiring that public secondary schools provide equal access to limited public forums without discriminating against students on the basis of religious, political, philosophical, or other content of speech. Yeah, so the contexts are different. The educational environment is also different than the work environment because, generally speaking, your employer can discriminate against you on a First Amendment contact as much as they want. You know, there are limits to everything, but generally speaking, they can. But in terms of schools, they're required to allow free speech. And because they're required to allow free speech, there will be incidents which would trip up one of these things. So in the interest of maintaining a First Amendment law, we're going to require all three in the educational context because we're also requiring them to have free speech, which we don't insist on in a private workplace environment because, again, adults. So, yeah. Similarly, an institution of higher education differs from the workplace. In regard, these final regulations are consistent with the sense of Congress in the Higher Education Act, amended that institution of higher education should facilitate free and open ideas. So yes, one of the fundamental purposes, and arguably the fundamental purpose of the university, is to allow a free exchange of ideas, which would necessarily, potentially, trip this up in a way that wouldn't necessarily apply at your typical employment environment. Education provides a different problem. The sense of Congress is that institutions of higher education should facilitate these free, robust of ideas, but such an exchange may prove disruptive, undesirable, or impermissible in the workplace. Yes, we're going to have to talk about things that would not be permissible in your average workplace, yes. Moreover, workplaces are generally expected to be free from conduct and conversation of a sexual nature, and it's common for employers to prohibit or discourage employees from engaging in romantic interactions at work. By contrast, it's become expected that college and university students enjoy personal freedom during their higher educational experiences, and it's not uncommon for an institution to prohibit or discourage students from engaging in romantic liaisons with each other. Yes, the college in terms of its interaction with a sexual-based environment is somewhat different than your average workplace, yes. The department does not wish to apply the same definition of actual sexual harassment under Title VII dealing with employment to Title IX dealing with education, because such an application would equate workplaces with education, whereas both the Supreme Court and Congress, again, these are findings of Congress, sense of Congress, so these are things that Congress themselves said in the bill. So both the Supreme Court and Congress have noted the unique differences between educational environments and workplaces in report to respecting the unique nature and purposes of educational environments. Yes, they are a little bit different than your average place for a whole host of reasons. As defined further in the harassment section of the new definitions section of the preamble, applying the same definition from Title VII to Title IX may cause to chill recipients to chill and infringe upon First Amendment. Yes, it would lead to infringement of First Amendment if we allowed any of them to apply. Again, we don't really care that much about the workplace because first of all, people don't live there, so there's that. The workplace is not devoted to free speech, most workplaces. So your average run-of-the-mill, the average run-of-the-mill factory doesn't present these problems. Schools do. So it would be inappropriate to apply Title VII to here. So the people came forward with a reasonable ask, because again, the law does, from Title VII to Title IX, they do kind of read on each other quite a lot. They came with a reasonable ask, apply this from Title VII here. They said no because of these cases and these congressional findings. Pretty solid reasoning, right? Now, they could have done something different. They could have. There's nothing stopping them. That's obvious. There's nothing stopping them. Because the context of those Supreme Court cases and the context of those findings are not identical. So presumably they could have adopted it, but they didn't. They didn't want to do that. Okay. The Department's use of Davis's definition of sexual harassment in the file regulations returns the Department to the stated intent of the 2001 guidance. The Department's definition of sexual harassment should be consistent with the definition from Davis. The Davis definition adopted in these file regulations, adapted by the Department's inclusion of both quid pro quo and the Floor Cleary Act offenses. So we're going to adopt the definition, and we're also going to extend it in these other ways to bring into conformity these other statutes, which is cool. Will help to prevent infringements of First Amendment freedoms, clarify confusion by defining sexual violence independent from Davis, clarify the intersection of these various laws with respect to sex-based offenses, and ensure recipients must respond to students and employees victimized. Fine. Recipients may continue to address harassing conduct does not meet the sexual definition as acknowledged by the Department to clarify that dismissal of formal complaint because the allegations do not meet this definition. Fine. All right, so then we're going to define actual knowledge. We might skip a little bit through this. We might speed read through this one a little bit. So we're going to adopt the definition of actual knowledge. It's recipients. Yeah, again, we're looking to the college's misconduct. So it's recipient's misconduct, not the behavior that presents liability. So we're looking to what the university is doing wrong. The Supreme Court held damage remedy will not lie unless they fail to adequately do stuff. So we're looking to what the college did or did not do. If they fail to do stuff, that's a problem as far as the Supreme Court is concerned. The Supreme Court rejected theories of vicarious liability just because our employee did it, not enough. The administration has to know. And constructive notice, not good enough. The Supreme Court notes that the department held schools liable under these theories. Neither of these decisions indicate where the administrative enforcement should continue to rely on them for the recipient's obligations. So yes, so not appropriate in these private contexts, but again, we're not in the same context. The file regulations adopt actual knowledge condition from the frameworks, so the file regulations clearly prohibit a recipient's own intentional discrimination, but they adapt the condition of actual knowledge to include a notice to more recipient employees than what's required on the framework in a way that takes account of the different needs and expectations of schools with respect to the violence or harassment. File regulations of adapted condition of actual knowledge in a way that's similar to and different from the guidance with respect to notice. In other words, we tailor this to our needs. Fine. The department guidance uses responsible employees rubric to describe the pool of employees to whom notice triggers a response. The responsible employees rule does not differentiate between elementary and secondary schools and post-secondary education. Again, we could, because presumably, we could treat elementary, middle, and high schools differently than colleges, but we don't have to. For all recipients, this guidance has stated that a responsible employee was an employee who has authority to take action and redress or has a duty to report to appropriate officials. Under the reasonable guidance official, the recipient was liable when a responsible employee knew or a responsible employee should have known. For reasons below, the final regulations do not use this rubric, although the final regulations essentially retain the first three categories. As discussed below, we depart. Rather than use the phrase responsible employees, the final regulations describe the employees to whom notice triggers the response. The pool of employees is different in education than in secondary. So we could, and in fact are. So in our prior guidance, we didn't differentiate. In this rule, we are going to differentiate. We could treat them differently, and we are going to do so. For all recipients, notice to the recipient's Title IX coordinator or any official of the recipient who has authority to institute measures constitutes actual knowledge to the recipient and charges these obligations. Determining whether an individual is with authority is a legal determination depends upon the specific facts. The Supreme Court views these officials as equivalent to what the statute calls an appropriate person for the resolution of Title IX. Lower courts apply the framework and reach various results to whether certain employees in schools are officials. Because the final regulations adopt these conditions requiring notice as resulting from notice to official with authority, but also include Title IX coordinator and any elementary and secondary employees. So any elementary and secondary school employee will do fine, but not any professor in a college. So we're going to differentiate it. So if a professor chooses not to report, they don't have to. Under the final regulations in elementary and secondary schools, notice to any employee triggers the responsibility. Under the final regulations, the elementary schools must respond, blah, blah, blah. In post-secondary institutions where in loco parentis does not apply, so in the place of parents, right? So in loco parentis is a theory that the school administrators are acting in the place of parents, and therefore they have the same rights as the parents in a lot of situations. That's in loco parentis. And I've actually seen some cases in colleges with in loco parentis, but it's been a long time, so I guess the Department of Education is saying, no, not so much. So in post-secondary cases where in loco parentis does not apply, notice to the Title IX coordinator or any official with authority constitutes actual knowledge, triggering the recipient's obligations only when Title IX coordinator or any official with authority has notice with respect to the autonomy of a complaint. As discussed below, the approach in the final regulations allow a post-secondary institution to decide which of their employers must, may, or must only with student consent report sexual harassment to the Title IX coordinator. A report to whom triggers the response obligations no matter who makes the report. So this is allowing. So there is a difference between the way this is being done in the case of below 18 elementary, secondary schools, which is elementary, middle school, high school, K through 12, right, and colleges. So in the case of K through 12, under 18, the Department of Education says a response to any employee is enough. Every employee must report up and must report it to an official that has the authority, the Title IX coordinator, the principal, whatever. And some states may also require reporting to a health authority. That might either be themselves or it might be through the principal or whatever, but we don't need to get into that. But there's a mandatory reporting requirement for anyone K through 12. And the logic there is fairly simple. If you come into, because we're trying to protect children who are not in a position to protect themselves, whose parents may be the ones doing the abuse, right? So if you're a K through 12 teacher, any teacher or any official, it looks like any employee, it looks like, if you come into knowledge, you have a duty to report that up. That's because that person's not in a position to protect themselves. Their parent may not be in a position to protect themselves. You have a duty to report that up to the principal, and then may have to be reported to state government in response to law. So you're a mandatory reporting person. Everything must be reported, okay? But what these regulations from the university is saying is creating a rule that says a person, a student, for example, might want to tell a professor about something that's happening to them and it not be reported. They might not want it to be reported. They might want to not report, but they might want to tell someone. So this is allowing for that if the university wants it to. So the university has a choice. The university can do whatever it wants, it looks like, from this. The university can make everyone a mandatory reporter, or it can say, we're going to create rules that say you don't have to report, you do have to report, or you have to report if the student says you do. So we're going to create the ability for a student to come. We're going to create the ability to say, faculty members, you don't have to report. You can keep the kids' confidence if you want to and they want to. So you can keep it. Or no, in the alternative, we're not going to allow that. You have to report. So there's no one you can talk to about it. without being reported. Or we're going to create a rule that says you only have to if the student makes you. So if the student says, yes, I want you to report it rather than me, because I don't feel comfortable going to the Title IX coordinator, I feel more comfortable talking to you, professor who I have this relationship with. So I don't feel comfortable talking to the administrator myself. I don't feel comfortable making that report. But I feel comfortable talking to you. Will you report it for me? And if they say, will you do it? Then you have to. So you have the option as the university to make that choice about, should every professor report? Should they be able to keep it secret? Should they have to report if the student says so? It's up to you to make that determination. And you, by doing so, can create who you have liability for. Because you only have liability for the people who have knowledge or should have knowledge, who are official reporters. So you don't have liability if the student tells a random professor and you haven't designated them as liability. It's up to you. You can do it. And if you want to, no problem. But if you want to say it's only these people, no problem. And that's also, incidentally, why the rules that we read earlier, the rules make clear the university is under an obligation to make sure to publish to every student who is the Title IX coordinator and give their contact information. So we're not hiding the ball. So if you want to make a report, you can make a report to this person. This is our designated official employee. You can make a report to that person, no problem. Your report will be addressed. So so we're telling you that you can make this report to someone else, but we're also maybe creating a flexibility that we want you to have the ability to give a confidence and that be held in confidence if you so choose. It's up to you how you want to choose to handle that. So it'll be interesting to see how various universities deal with that. Because again, these are adults. They're over 18. They're adults who are in a position to defend their own rights if they want. And if they don't want to make a report, they shouldn't be forced to. So you're in a position to make the decision for yourself. Pretty interesting. Pretty good stuff. And that there didn't used to be a difference before. So everyone had to report, and now there is. So now you can have these designations different if you want. Which to my mind makes more sense, I suppose. It makes more sense to me. If I know who to rat out to specifically, then if I want to, I can call them. And if not, not. With respect to post-secondary institutions, that would be, again, colleges, the final regulations depart from other two categories described in the guidance, as described below. In these contexts, regarding latter two categories to be mandatory employees, have resulted in university policies that have unintentionally discouraged disclosure by leaving complaints with too few options to discuss harassment without automatically triggering a response. Yes, it has created a problem. People aren't feel free to come forward. Elementary and secondary school students cannot be expected to distinguish this, but schools at post-secondary institutions may benefit from having options to disclose this to people who will keep it confidential. The final regulations ensure that all students and employees are notified of the contact information for the coordinator and how to report it for the purpose of triggering a response. So you're under an obligation to make this clear to people so they know where to go if they want to. And the department believes the students at these institutions benefit from retaining control over whether and when the complaint should come forward. So if a person wants to make a complaint, they can. If they don't want to make a complaint, they don't. And they have control. They have control. And they have the ability to talk with people and not be ratted out. Under the old rule, they couldn't confide in a professor. A professor was required to rat them out. And now they may not be required to anymore. So I think it's probably better. Obviously, we can't expect that of elementary school students. I don't think all the publications and all the manuals in all the world would make it clear to a person who's in elementary school. So, yeah, we'll allow mandatory requirement. Mommy hits me sometimes is a little bit concerning, yeah. In both elementary and secondary school contexts and the post-secondary institution context, final regulations use the same broad notice of what constitutes notice. So there's no difference on what constitutes notice. Notice constitutes whenever whoever has authority gains knowledge by, for example, witnessing it, hearing about it, or hearing about allegations from the complainant or a third party, receiving a verbal or written complaint about harassment, or by any other means. So if they come into knowledge through any means, These final regulations emphasize that a person must always trigger a recipient's response obligations by reporting the harassment to the Title IX coordinator using the contact information. The person who reports does not need to be the complainant. A report may be made by any person who believes it's sexual harassment. So you don't need to be the complainant. Any person can make a complaint. And presumably any other student can make a complaint on behalf of someone else too. But there are options here where there weren't before. The final regulations depart from the constructive notice condition described in the guidance about should have known. Okay. The department guidance gave only a following example of should have known. When known incidents should have triggered an investigation that would have led to discovery, or in pervasiveness leads to the conclusion of should have known. Okay. The department has reconsidered the position that a recipient's response obligations are triggered whenever employees should have known, because known incidents should have triggered an investigation that would lead to discovery of additional incidents. So under the old guidance, because you knew of certain particular incidents, that created an obligation to look into other things that might have occurred, which may not exist. Be like, because these cars were broken into, maybe we should check all the cars. Not necessarily, it doesn't necessarily flow, right? The following regulations impose clear obligation as to when a recipient must investigate, unlike guidance, which does not specify the circumstances. The final regulations clearly obligate a recipient to investigate and adjudicate whenever a complaint files or Title IX complaint signs a formal complaint. The department will hold recipients for failure to refuse to investigate. However, the department does not believe it's feasible or necessary to speculate on what an investigation would have revealed if an investigation had been conducted. So, if no investigation occurs because no investigation was required, then we don't have to speculate about what it would have happened. Even if there are additional incidents of which a recipient would have known, had the recipient conducted the investigation into a known incident, each of the additional incidents involved complaints will also have clear options and rights under the final rule to file complaints that requires an investigation or to report. If a recipient fails to meet its Title IX obligations with respect to any complaint, the department would hold the recipient responsible, and doing so does not necessitate speculating about what an investigation would have done. So it looks like should have known is off the books. It's only about what you actually know, at least as to secondary school. So it's only about things you actually know about, not things you should have known about. So if during your investigation you turn up additional information, presumably you would be under an obligation to investigate it because now you know. But if you don't investigate because no investigation was required, then we don't have to speculate about what you would have found. Seems a lot clearer. The department has reconsidered the position that recipients' response obligations are triggered whenever they should have known. In elementary and secondary schools, the final regulations charge a recipient with actual knowledge whenever any employee has a notice. Any employee will be fined. Thus, if sexual harassment is so pervasive that employees should have known, for example, graffiti, it's highly likely that at least one employee did know about it and school is charged with actual knowledge. So yes, if it was so pervasive that someone somewhere must have known about it, so that makes sense. We can impute the knowledge because if it's pervasive, someone had to know. How can it be pervasive and no one who's an employee knows? That would be a neat trick, right? It's pervasive, yet no one actually knows. So that makes sense. If everyone is an obligation to report, then yes, someone somewhere must have known. So that would make sense. There's no reason to separate the should have known standard to cover situations that are these pervasive in elementary and secondary schools. In post-secondary institutions, where sexual harassment is so pervasive that some employees should have known, it's highly likely at least one employee did know. However, in post-secondary institutions, for reasons discussed, the Department of Police complainants will be better served by allowing the post-secondary institution recipient to craft and apply the recipient's own policy with respect to what employees must, may, or must only, with respect to complainants' consent, report the harassment and sexual harassment allegations to the Title IX coordinator. With respect to whether a Title IX coordinator official with authority should have known of sexual harassment, the department believes imposing should have known standard unilaterally creates a negative incentive for Title IX coordinators and officials to inquire about harassment in a way that invades the privacy and harassment. And such negative consequence is not necessary because the final regulations provide every student and employee with clear channels, which gives Title IX court notice and triggers responsibilities without the need to require the officials to evade students. So we're not going to do this should have known thing in the post-secondary environment, in the higher education environment. We're not going to do should have known anymore. In the elementary, middle, and high schools in K through 12, yes, because if it's pervasive, someone had to know. But now, no, because now we've created a situation where not every employee has a duty to report. So yeah, someone somewhere may have known, but they didn't have a duty to report. So the pervasiveness would only be if a person who had a duty to report should have known, presumably, and that's much different. And again, everyone can report themselves and is an adult and has the ability to report. So again, and it doesn't apply to kids who may not have the ability to report in any real sense. So we have to have a different standard to protect people who can't protect themselves. These people are adults and can protect themselves. They can report themselves. We're not going to should have known as applies anymore. And again, we might want people the ability to choose. We might want it for victims to have the right to not talk about it if they want to. That's an option. And now that option exists. So you can't be held responsible for something you should have known when you shouldn't have known because it was being kept secret because of this. I mean, to my mind, all this makes perfect logical sense and is consistent with respect to the victim, where we make it clear to the victim where you can report. Anyone who has a duty to report can know. Anyone has the right to report or not. It's up to you. It's your choice. So, and the Title IX coordinator can still file their own stuff. And if they come into knowledge, they can still investigate other stuff. They're not being limited in their power to investigate. They can still investigate beyond what's being reported to them. But this gives power to the people being assaulted. So it makes perfect sense to me. The guidance did not use the term mandatory reporters, but appropriate school officials. Well, whatever your nomenclature, it's the same thing. Blah, blah, blah. Throughout these final regulations, blah, blah, blah. Though actual knowledge, skip. Deliberate indifference. We have to actually do something about it. We revise it that must be prompt, must consist of supportive measures, must ensure contact each complaint to discuss these measures, consider the wishes, record the measures in form of supportive measures with or without filing complaint, explain the process for filing the complaint, proactive measures, blah, blah, blah. The guidelines set forth in liability, more like reasonableness. Okay, fine. I don't care about any of that. That's fine. Role of due process in the grievance process. All right. Role of due process. This is probably what you all came for. We finally got to the due process thing in an hour and a half. So we're going to discuss the role of due process. This is where the money really hits the road, right? This is where it really hits the road. What does due process look like? This is gonna be good. Brace yourself. As discussed above in the adoption section of the preamble, the Supreme Court has held sexual harassment is a form of sexual discrimination, and the recipient commits discrimination when they know or should have known and in a manner that's deliberately indifferent. However, they not specified conditions under which a person must initiate proceedings against a person or what procedures must apply as part of the response. Similarly, the Supreme Court has not addressed the procedures they must use in resolving the harassment guidelines. So we have some initial guidelines. Guidelines since 1997 have an obligation to respond by prompt and equitable treatment with respect to what constitutes equitable. The 2001 guidance mean procedures that provide for adequate, reliable, impartial investigations, including the opportunity to present witnesses and other evidence. 2001 guidance advise the specific steps will vary. However, in all cases, the inquiry must be prompt, thorough, and impartial. The 2001 guidance advised the recites established under Title IX must be interpreted consistently with any federal guaranteed due process right interpreted in a complaint proceeding. Well, not so much after the Dear Colleagues letter, at least. Procedures ensure that Title IX rights while at the same time affording due process. The withdrawn 2011 Dear Colleagues letter mentions due process only with respect to recipients that are state actors, implied that due process only benefits the respondents, and implied that due process may need to yield to protect complainants. Public and state support schools must provide due process to the alleged perpetrator. However, schools should ensure that steps taken to accord due process rights to the alleged perpetrator do not restrict or unnecessarily delay the protections for the complaint. These final regulations built on the premise of the 2001 guidance. Title IX cannot be interpreted in any manner that denies any person due process of law under the Constitution. The following regulations reaffirm the premise expressed in the guidance that due process protections are important, both for complainants and respondents, do not exist solely to protect respondents, and result in a sound and supportable decision in sexual harassment complaints. Yes, the following regulations, however, provide recipients with prescribed procedures that ensure Title IX is enforced consistently with both constitutional due process and fundamental fairness, so that when a student attends a public or private institution, the student has the benefit of a consistent, transparent process with strong procedural protections regardless of which side of the line they're on. Neither the 2001 guidance, nor the 2011 guidance, nor the Q&A inform procedures as to what would be adequate, fair, and reliable, and consistent with due process. While the department's guidance appropriately and beneficially drew attention to the need to take sexual harassment seriously under Title IX, the lack of specificity of how to meet these obligations while ensuring due process has led to an increasing number of lawsuits and complaints against recipients since issues of the now later, alleging that the recipients have mishandled Title IX cases regarding injustice. Public debates have ensured questioning of whether recipients should leave criminal matters like sexual assault to the criminal justice system, or whether Title IX requires recipients to do both, to respond meaningfully to allegations on campus while also providing for protection. The departments believe that recipients can and must do both because sexual harassment impedes sexual equal opportunity and because no person's constitutional rights or right to fundamental fairness should be denied. These final regulations help to achieve both. Somehow, my brethren on the more progressive left will come to oppose due process once again because reasons, I don't know. But yes, we must do both. Beginning in mid-2017, when the department started to examine how schools, colleges, and universities were applying to Title IX, what happened in mid-2017 where there was a change? What would have happened? What would have happened in early 2017 that might have caused a change? I can't put my finger on it. Yeah. Beginning in mid-2017, when the department had started to examine how schools and universities were applying Title IX under the then applicable guidance, one of the themes brought by the department's attention during listening sessions and discussions was that in the absence of regulations explaining what was fair, equitable procedures compliant with the constitutional guarantee, was that recipients have interpreted and applied the concept of an equitable grievance process in the harassment unevenly, and at times employing procedures incompatible with the process. That's one way of putting it, yes. And also principles of fundamental fairness and lacking in reliability. As noted throughout the preamble, including the personal stories section, so again, 500 pages, they went through a lot of material, right? Commentators described how grievance procedures applied under the old rules have lacked basic procedural protections and have appeared biased for or against complainants or respondents. The result has been unpredictable adjudication systems under which complainants and respondents too often have been thrust into inconsistent, biased proceedings that deprive one or other of the parties of fair process and result in some determinations regarding responsibility viewed as unjust and unfair to complainants and other determinations regarding responsibility viewed as unjust and unfair to respondents. Compelling stories of complaints whose allegations go unheeded by institutions and respondents who have been found responsible and harshly punished for sketchy procedures, that's one way to put it, have led to a debate about the issue of how to investigate this and challenges to find a way to engage these stories from different perspectives because the regulations could be better or, exist at all. That would be good. The department believes federal court's recognition of sexual harassment as sexual discrimination under Title IX, the guidance advising recipients on how to respond to allegations, and these final regulations represent critical efforts to promote the mandate. With respect to grievance procedures, the final regulations build upon the foundation set forth in the guidance, yet set forth additional clarity and instruction as to how they must provide for the needs of complainants with strong procedural rights that ensure due process for both complainants and respondents. These procedural rights reflect the very serious nature of sexual harassment and life-altering consequences that might follow determination. We believe that these processes will ensure the recipients apply a fair, truth-seeking process that ensures the interests of complainants, respondents, and recipients and actively responding to the allegations. The grievance process does not codify current department guidance, because of course it doesn't, but does build upon the principles recommended in the guidance while prescribing certain procedures to be consistently applied to recipients to improve the procedures. At least one state recently considered codifying the withdrawn leader. That would be California. Yeah, California considered codifying the old letter in its law. because of course it would. Way to go, California. And deciding instead that an approach much like these would be advisable. The Honorable Brown, former governor of California, I told you it was California. I knew it was California. Would have vetoed statement asserting. So even California has limits. It's nice to know. Sexual harassment and sexual violence are seriously complicated matters for schools to resolve. On one side are complaints who come forward to seek protection. On the other side stand accused students who, guilty or not, must be treated fairly with a presumption of innocence until the facts speak otherwise. Then, as we know, there are victims who never come forward and perpetrators who walk free. Justice does not come easily in this environment, though legal minds have increasingly questioned whether federal and state actors to prevent and redress sexual harassment and assault, well-intentioned as they are, have also unintentionally resulted in some colleges' failure to uphold due process. A little bit, yes. Depriving any student of higher educational activity should not be done lightly or out of fear of losing funding. Governor Brown's then convened a task force or working group to make recommendations. I don't care about California. Whether due process is conceived in terms of constitutional due process owed by state, or in principles of fundamental fairness owed by private actors, file regulations prescribe a grievance process grounded in principles of due process for the benefit of claimant and respondents seeking justice in each situation that arises in educational program activity. So yes, whether or not we're thinking about this in terms of the Constitution or in broader terms of just fundamental fairness, we probably should be doing something, because what we had before was not what I would describe as fundamental fairness. No. Due process describes a procedure that justifies its outcome. It provides reasons for asserting a treatment that they receive is fair. Due process fundamental guarantee. It appears in criminal law, civil law, and administrative law. Due process is a peculiarly American phenomenon. No other legal system has anything quite like it. I'll leave it to you, members of other countries, to determine the degree to which your countries do or do not have due process. But at least according to the Department of Education, we're in a class of one. No one else is quite like us in terms of due process. We're the best when it comes to due process. It's a peculiarly American invention. Given what little I know about UK law and how it's developed since the separation of America from the UK, I'm somewhat inclined to believe that the US has greater due process protections than our brethren in the UK do these days. So yes, it may be peculiarly American, but it's great. Argue amongst yourselves whether or not your country has due process or not. Due process is a legal principle which is shaped and developed through the process of applying and interpreting the Constitution. Due process is a principle which is used to generate a number of specific rights, procedures, and practice. Due process may be thought of as a demand that procedure conform to the requirements of justice, and justice is a basic feature of our idea of rule of law. Research demonstrates that people's views about outcomes are shaped not only by how fair or favorable an outcome appears, but also the fairness of the process through which it was rendered. Yes. A fair process provided by a third party leads to higher perceptions of legitimacy. In turn, legitimacy leads to increased compliance with the law. Fair process or procedural justice increases outcome legitimacy and thus increased compliance because it's likely to lead to an accurate outcome and send signals about an individual's value and worth with respect to society in general. The grievance process prescribed in these final regulations provides a fair process rooted in due process. Due process is good and important. Blah, blah, blah. The department is subject to the Constitution and will not interpret Title IX to deprive a person of due process. We look to Supreme Court guidance. While due process of law in some contexts is especially concerned with protecting rights, the department views due process as critical for both sides. This is nice. Nice. Quoting RBG. In the words of the Honorable Ruth Bader Ginsburg, Associate Justice, discussing the Me Too movement and the search for balance between sex equity and due process, it's not one or the other, it's both. We have a system of justice where people who are accused get due process, so it's applying the field to where we've applied it generally. RBG, man. You gotta love, yeah, I throw out the RBG quote, that's good. Precisely because due process is a flexible concept demanded by the concept of a particular situation. Yes, different process is different in different kinds of situations. That is very true. What is due in any given situation is different. Like due process in criminal law is not the same in civil law, is not the same in administrative law, blah, blah, blah. So the process that is due can differ. Yes. So it is a flexible concept that's dependent on circumstances. Yes. The department recognizes that due process in the particular situation may dictate different procedures than might be appropriate in other situations, for example, a criminal trial, or administrative context of a government agency for administrative benefits, or educational context involving misconduct. Allegations of harassment in an environment present unique challenges. Due process in elementary and secondary schools differ from those in colleges. Procedural rules in these guides apply only to post-secondary institutes. Recognitions that post-secondary institutions present different situations in elementary and secondary schools. For instance, most elementary students tend to be of underage majority, so same procedural rights generally cannot be exercised effectively. For example, unlike post-secondary institutions, elementary and secondary schools are not required to hold a hearing under the regulations. So again, in the interest of protecting children who are unable to protect themselves, we have different rules. Makes sense. The following regulations aim to accomplish the objectives of a consistent, predictable. I mean, we don't want to infantilize college students, right? We don't want to make college students under the same rules as elementary school students, right? We don't want to infantilize college students, right? My friends on the more progressive left, we don't want to infantilize them. So maybe we should treat infants as infants and adults as adults. Makes sense? Or do we want to infantilize college students? Skip, skip, skip. Skip, skip, skip. Skip, skip, skip. All right. As a whole, now we're going to get into a summary of what it is. So now that we've justified that due process is good, let's talk about a summary of what it is. What is the due process? As a whole, 106.545 contains 10 groups of provisions that together are intended to provide a standard framework that governs recipients' response to a formal complaint under Title IX. 1. Acknowledges a recipient's treatment of a complaint or respondent could constitute sexual discrimination as defined by Title IX. 2. Requires a recipient to adopt a grievance process that treats complainants and respondents equitably by recognizing the need for complainants to receive remedies where a respondent is determined responsible, and for respondents to face disciplinary sanctions only after a fair process determines responsibility, objectively evaluates all evidence, both inculpatory and exculpatory, and requires rules voluntarily adopted by the recipient treat the parties equitably, requires Title IX coordinators, investigators, decision makers, and persons who facilitate informal resolutions to be free from conflicts of interest and bias and be trained to serve impartially, presumes non-responsibility of respondents until conclusion, includes reasonable response frames, informs all party of crucial information about the procedure, including the range of remedies and disciplinary sanctions, standard of evidence to be applied, which must be either preponderance of evidence standard or clear and convincing evidence standard. I assume one is for colleges and one is not, but we'll get into that. I don't know what that means, so we'll get into that. The recipient's appeal procedures and range of support measures and protects any legally recognized procedure privilege from being pierced during a privilege. So you can't get to privileged information. Cool. Requires notice of allegation to the parties, informing them of its right to seek an advisor of their choice. Requires recipients to investigate formal complaints. Requires them to notify the parties. Requires recipients to investigate formal complaints in a manner that keeps burden of proof of gathering evidence on the recipient while protecting the right of every party's right to consistent use of their own methodological, psychological, and treatment records. So again, privileged information you can't get to. Provides parties equal opportunity to present facts and expert witnesses. So both sides can present witnesses. Does not restrict the parties from discussing the allegations or gathering evidence, so you can talk about it if you want. Gives the parties equal opportunity to select an advisor who may be, but need not be, an attorney. So both sides can get an attorney now. And that's a pretty big deal. Both sides can get an attorney if they want. My recommendation here to anyone accused of sexual assault under the new guidelines is get a damn attorney, please. Please get an attorney, please. Please. It'll be worth it. Requires written notice of participation is inspected or for interview. I'm very, very sorely tempted when I become a member of the Texas bar. I'm very, very sorely tempted to put up a shingle, as it were, and start offering my services as a Title IX defense attorney for these things. I do live right next to the campus of the University of Texas. I could put up flyers. I could become a defense attorney for Title IX cases. Something to think about. Something to think about. I might have to start offering my services now. Requires written notices when a party's participation is expected, provides both parties equal opportunity to review and respond to evidence, sends both parties investigative report summarizing the relevant evidence prior to reaching a determination. The section requires a live hearing with cross-examination conduct by both parties at post-secondary indications while making hearings optional for elementary and secondary schools. Requires a decision maker who is not the same person as the Title IX coordinator to reach a determination regarding responsibility, which must either be preponderance of evidence or clear and convincing. I might have to just Google around or something and look for that and figure out what the basis of that is. Requires recipients to offer appeals equally to both parties. Requires respondents to offer and facilitate informal resolution process. Requires them to maintain records. The department concluded the above provisions root in due process set forth these process with effective protection. Okay. Excuse me 1 second. I'm going to open this in a new window because I'm reading it live with you. So I want to see if I can find what the difference on preponderance or when one is being adopted and one is not. Oh Lord. Hold on while I Google. Hold on while I Google, see if I can find out what is being used when. So what happens when you have 500 pages and you try to do it live? $1.99 from Ghost Recon. I'll be near UTA tomorrow if you want to do lunch. Cool. We should have lunch. Let's do lunch. Now that restaurants are opening again. I assume University. What is UTA? University of Texas at Austin? Okay. Because I had to think about it. It's because I'm not from here. Sure, we can have lunch. I'm having a little bit of trouble finding when is what's supposed to be used. All right, so I found some commentary on this, in at least in the comments. So here's where I found some commentary on this in the comments. Looks like it might be pervasive or might be helpful. Commentators assert that clear and convincing evidence standard would enhance overall accuracy. One commentator argued that requiring clear and convincing evidence is essential because it would be unjust to have a mere 50% threshold to punish people. One commentator inserted it's especially important to raise the standard of evidence because in the current #MeToo environment, women are automatically believed and men are automatically guilty. This commentator argued that sexual misconduct cases often boil down to credibility and such allegations are virtually impossible to disprove. So here's what the Department of Education has to say about this issue. The department acknowledges that suggestions offered by commentators to mandate a higher standard of evidence than preponderance, such as clear and convincing evidence or beyond a reasonable doubt, which no, not so much, but clear and convincing makes much more sense. In recognition that sexual misconduct cases involve high stakes and potentially life-altering consequences for both parties, and such cases often impeding plausible narratives of truth alleged allegations, the department authorized the recipients to select either preponderance evidence or clear and convincing standard to reach the determination regarding responsibility. Why would a university pick clear and convincing if they have the option? That's unclear. Because Title IX proceeding is different in purpose and consequence. The department does not believe a criminal law standard like beyond reasonable doubt is appropriate in a non-criminal setting. I believe that's true. That I will agree with. Recipients are not court and do not have powers to impose criminal punishment. Yes. Recipients bear the burden of proof, but they do not have subpoena power. That's also true. The final regulations also provide for privacy protections for complaints and response, which prohibits them from accessing certain records without consent, even if the treatment records are relevant. The beyond a reasonable doubt standard is also rarely used in civil proceedings. Yes, that's true. We therefore decline to permit a recipient to select that standard of evidence instead, than select either two standards, each of which is used in civil matters. Yes, they are. The department shares commentators' concerns for protecting academic freedom of speech, and the section emphasizes that nothing in the final regulation requires restriction of rights otherwise protected. To further reinforce their rights, the final rights would explicitly prohibit the department from deeming recipients' rejection of rights protected under the First Amendment to be evidence that recipient was not deliberately indifferent. Thank you, $4 from Daniel Bowen for the super chat. That's super appreciated. Thank you. To further reinforce these rights, not deliberately indifferent. The standard must be either serious misconduct or the standard. When a formal complaint allegations constitutes sexual harassment as defined in the code, the department has concluded that robust procedural protections granted both parties means that preponderance of evidence standard or clear and convincing may be used to reach consistently fair outcomes. Contrary to claims made by one commentator, the Supreme Court has never required application of criminal beyond a reasonable doubt standard in Title IX, and the department is not aware of any federal court decision requiring adoption of that standard. The department believes requiring the standard in non-criminal proceeding is inappropriate. Well, that's not super enlightening. Because it's unclear why you would adopt one over the other. Let's see. Some commentators assert that the notice for proposed rulemaking presents a false choice because the proposed rules impose a one-way ratchet where schools may use either the clear and convincing evidence standard of sexual assault cases and a lower standard in other cases, but not vice versa, thereby disenfranchising complaints in sexual harassment but not others. Some commentators assert they lack authority to impose requirements in these proceedings. Okay, well, yeah. The department is persuaded by comments that raise that the prohibition of recipients using preponderance of evidence unless they also use that standard for non-sexual misconduct. Okay, so if you use a different standard in non-sexual misconduct, which why would you? Then you have to use it here too. But if you don't, then you have the flexibility. Okay. The department is also unpersuaded by the objection may have unintended consequences for choosing a standard of evidence, potentially exceeding the department. Simplified its approach. We acknowledge alternative approaches raised by one commentator would limit the appreciation. I'm honestly surprised that the Department of Education did not adopt clear and convincing as a mandatory rule. Because the final regulations grant recipients unrestricted right to choose between these standards, we disagree the final regulations relate heavy-handed. So apparently you can just pick either one. So that's annoying. So it looks like you can use either one. All right. Well, that is enough for now. We are nowhere near done, but we've been at this 2 hours and I'm tired. So if you like this stream, please give it a like. Thank you for all the super chats. So we got a lot of this stuff, and maybe we'll be back with part 2, and we'll cover some of the other stuff that we missed because I'm running way out of energy. So I hope you liked the stream. I hope you enjoyed it. If you did so, I appreciate a like as always. But yeah, it looks like at least there's going to be a lot more protections. I wish they had adopted clear and convincing evidence as opposed to preponderance of evidence. I wish they had adopted that by mandate, but they didn't. So, you know. Yeah. All right. So, till later, my friends. Peace and goodbye.